Hi there. Today I'm interviewing Amy Griboff. Amy's a local elder law attorney located in Rockville, Maryland. I met Amy through a group here in Montgomery County that focuses on education, advocacy, and networking for senior service professionals and organizations. I joined the group recently and was looking at the roster to get acquainted with other members, and I came across Amy's website and noticed that she had a YouTube video. So I immediately said, this is somebody I need to meet. We've had some great conversations, and now I'm going to, without any further ado, hand you over to Amy so she can talk about 3 mistakes you need to avoid with estate planning. So take it away, Amy.
Okay. Thanks, Harry. I have been enjoying our multiple conversations about estate planning and elder law. And I hope that we can get rid of some of these common mistakes so clients can have the greatest estate plan they can and be sure that their wishes are followed. So I guess if you want to just flip to the next slide, we're just going to jump right in. And so this is mistake number 1, that if you have a will, that there's no court involvement. And I actually got into estate planning because my mom died suddenly. I was named as her personal representative or executor in her will to manage her affairs after she had passed. And I didn't know anything about what that meant to be a personal representative. But I learned that that's usually about a year process. And so I actually went to law school then at that point after dealing with my mom's estate, and have been a practicing estate planning and elder law attorney for the last 20 plus years. And so, what I like to say about this mistake is that where there's a will, there's probate. There is a will. And just because your will says everything goes to my spouse or everything goes to my children, that happens, but there's court involvement. And as I mentioned, it's usually about anywhere from 6 months to a year process. And there's court reportings. And oftentimes people need to hire an attorney. Sometimes it's the attorney who drafted the will to help them go through that process. And so there's other techniques, which we won't get into today, but a teaser, there's other techniques that one could avoid the court involvement by using those techniques. But so just be aware that if you have a will, that means there's going to be a court involvement. And I think we'll just jump to mistake number 2.
Okay. So
Okay.
mistake number 2.
Mistake number 2 is I want a simple will. And so I must get this call at least once a week. Somebody says, I have a simple estate, I need a simple will. And usually what they mean when they say that is, I want a 1-page will, something short, simple. And then I'm there to educate them that maybe short isn't always best. And the type of estate planning documents that I like to draft are documents that are going to be flexible and that are going to provide, well, let me kind of explain what flexibility means. It means that we don't know what tomorrow is going to hold, obviously, and we want to draft documents that can protect us during disability or at death in regards to a will. And for a variety of different situations. And so sometimes I also like to call this where we're going to put in all the spare tires, and we're going to make this will flexible with lots of options because we don't know what's going to happen down the road. And I'd rather have a document that has something I'm never going to need, just like a spare tire. We all hope that we'll never need a spare tire. But if we do, it's in the back seat or the trunk, I guess.
Right.
And so the same thing with the will. We want to include provisions in there. For example, like a special needs trust is something that I might use in a document. And it allows a beneficiary who might be receiving government benefits to receive an inheritance from the person, but not lose their government benefits. So that's just an example of something that I like to have in my documents. Even if a beneficiary might not be on government benefits, we don't know what the future holds.
Mm-hmm.
And so better to have it than not have it. So that's mistake number two.
So well, when you were talking about the spare tire, it brought up something, reminded me of something, which I think sort of fits with what you and I have talked about before, which is you need to have your spare tire, but every once in a while, you need to check the spare tire and make sure that it's got air in it, because a lot of people don't. I know I don't very often, but I remember a mechanic telling me this years ago that every year or so you should just take your spare tire out and make sure it's got air in it, because a flat spare tire isn't going to do you any good, which I remember you talked about. You have to review the documents every once in a while.
Absolutely, Harry. I like to give my clients a list of reasons to review their estate planning documents. And I would love, my goal would be to have clients come in just for a checkup every year. Typically, it's more often like every 5 years or something like that.
Mhm.
But
That's
definitely need to check the document because laws change, family situations change. And so lots of good reasons to be sure it's up to date.
right. Okay, so we'll roll on to number three.
Okay. Mistake number three is a client comes in and they tell me that they want to name their oldest child as their executor of their will. So, again, if you have a will, we always have to nominate somebody in the document to, excuse me, manage your affairs when you've passed. And that person might be called the executor or the personal representative. And I think people will often think that, they'll just look to their oldest child as to be the person to serve in that role when they pass away. And that person might be fine. But again, I think it's a mistake to just assume and just choose that person. And so my role when I'm meeting with them is to kind of go over and understand, well, have you just picked this child because they're oldest, or to kind of discover more about the child or who the person might be naming? Maybe it's not a child,
Mhm.
but maybe it's a friend or a family member, and discover whether there's somebody who is going to manage the person's affairs. Sometimes I find out that the person that they're thinking about nominating has filed for bankruptcy or can't pay their bills on time and isn't responsive um, to you know the the, because having will is a court process and you have to respond. So if the court asks you a question or gives you deadlines,
Right.
and they do a variety of different documents, you have to meet those deadlines. And if not, you're going to end up being called into court, or that person nominated will be called into court and possibly removed. So again, we want to create the best estate plan and the best documents so that we don't have to have anybody removed, because that's just not a really fun way to spend somebody's time and money. If they've created a will, we want it to work. And so nominating somebody who's going to be responsible and be able to handle court deadlines is really important.
Yeah. So what would happen if the court removed somebody? Does the court then appoint? I assume the court then sort of takes over and appoints somebody to finish the job, or does the court do it? Or just curious.
Yeah, no, it's a great question. So again, because we want to make documents flexible, we always want to name. So that kind of brings me to the situation where I was not only probating my mom's estate in through the court because of her will,
Hmm.
but my grandmother, my mother's mother, um, had done an estate plan and only named one person. And that was my mom to make her financial and medical decisions. And when mom predeceases
Ooh,
grandma, grandma has nobody.
right.
And so then I ended up filing for guardianship. Thankfully, the court appointed me.
Mhm.
But anytime the court is involved, they can appoint somebody, they can appoint an attorney instead of the person you've named in your document. But in the if the personal representative is removed because they're not following court deadlines and things like that, um, then again, we hope that we look to the will or the legal document and that there's a backup in the document. Don't do what my grandmother did. She had nobody. Okay, so we want a backup. And hopefully that the backup will then step in and the court would appoint the successor to step in and take over, but doesn't
Huh.
always happen.
Right. Right.
So
Um, Belt
so
and suspenders. Right. Always, important to have a B plan.
yes, have a B plan and check the documents. And I was just having a conversation with somebody yesterday. If you have somebody who's 18, probably the legal Zoom document might be just fine for them to have.
Hmm.
Um, but probably anybody over the age of 18 that has assets and wants to be sure that their wishes are followed really needs to consult an attorney so that we can guide them to avoid court involvement, be sure that the right people are appointed, and make a really flexible document that's going to work for them.
And how old does someone have to be appointed as a personal representative? Or
So they do have to be a competent adult. So they have to be competent. They have to
okay,
be an adult. They have to be over the age of 18.
got it.
And then there's also requirements about having uh, I forgot the exact wording, but they're looking for somebody who has, they actually ask on the petition when you're filing the will with the court, if you've ever committed a felony or,
Hmm.
if you are a good standing human being and,
Pay
and
your
if you,
taxes? They
that
ask
they
that
don't,
question?
they don't ask if you pay your taxes, but if you've been, uh, if you have any criminal
Yeah.
background or civil actions against
Mhm.
you, you might have to end up explaining why you should serve as the executor of somebody's estate. So, but don't run into that very often, but it
Got it.
does come up. So,
Okay.
all right. So,
Well, thanks so much. That was great. Really good information. And if people are interested in getting more information about you and your practice, I've put a link below in the remarks to your website so they can learn some more. And you and I had also talked about a part two. And if you'd still like to do that, you and I can talk and we'll get that on the calendar and get that set up. Okay,
okay. Sounds great.
great.
Thanks so much. Appreciate
So
your time, Harry.
absolutely. That's it. And I hope everyone has a great day. And I'll see you all on the next video. Bye
Okay.
bye.
Bye.